Yes, I am capable of doing such.
My children.
Can you hear me? No?
Testing, testing.
Thank you, babe. You're welcome.
Hello?
Ladies and gentlemen, please take your seats. We're gonna get started in the next 5 minutes. All right, we will get started. Council members, please get in your seats so we can get started. And I believe I'm just calling this meeting back from recess, correct? Okay, make sure we're all on the same page.
Just give us a minute, council member.
No problem. All right. Ladies and gentlemen, I am calling this meeting back into order from recess. Madam Clerk, when you're up and running, can you take the roll, please? Thank you.
You need to order another one of those things. Roll call. Councilmember Thomas, Councilmember Green, Councilmember Morrell, Councilmember Moreno. Present. Councilmember King, Councilmember Harris, Councilmember Jeruso. We have 6 members. We have a quorum.
All right, we are picking up where we left off 2 weeks ago. I do have a brief statement I'd like to read only because so much time has passed between when we started this process and today. I think a refresher might be in the best interest of everyone who is in chamber as well as watching from the public. I want to begin by thanking everyone for being here today. This is an unfortunate historic occasion, and public participation with transparency is the foundation of any democratic process. So I believe it's best to start this process with a simple explanation because the issue before us as a council is not terribly complex. Over $50,000 of public taxpayer money was spent on a political mailer. Gregory Joseph tried to cover up this expenditure and the political rationale behind it by clumsily manipulating the procurement process. After a lengthy investigation providing hard evidence that confirms this, rather than admit culpability, Mr. Joseph doubled down by repeatedly lying to not only the council, but the public under oath during a hearing held as part of the investigation. The administration was given every opportunity to resolve this issue internally as part of this process and terminate Mr. Joseph. However, despite the overwhelming evidence, the administration chose not to do so. So we are here today to complete the process by hearing the charges with supporting evidence and making a decision regarding Mr. Joseph's status as an unclassified employee of the city of New Orleans. That's it. It's that simple. Mr. Joseph was made aware of this process as well as the administration on September 12th when the charges were presented to both parties. Further, they were both notified as part of this process that they had until September 22nd to provide the council with a list of witnesses and or exhibits they intended to use. There has been no communication from Mr. Joseph on or before September 22nd in this regard. Despite all of this, the council gave Mr. Joseph a continuance 2 weeks ago at the urging of the city attorney and in the interest of fairness. Despite these accommodations and our good faith efforts, there has been no direct communication from Mr. Joseph or the administration before this hearing today since we last left, and there has been no communication with Mr. Joseph or anyone representing him since the original charges were sent over on September 12th. There have been multiple opportunities to participate in this process to no avail. Therefore, this council must move forward with ensuring accountability because if not now, when? These are the facts before we begin this hearing today. I now turn over everything to Mr. Swinzig, who will be presenting the charges as part of this process.
Good morning, council members. Can you hear me okay? My name is Adam Swensick. I am fortunate to be executive counsel to the New Orleans City Council. Councilmember Morrell, in light of the extraordinary and unprecedented nature of what we're doing here today, asked me this morning to lay out the charges against Mr. Gregory Joseph in depth. Some of this was covered in Councilmember Morrell's remarks, but my presentation today is the culmination of a council investigation that began last March into an advertising campaign that was funded with taxpayer dollars. The council subpoenaed thousands of documents from city officials and from third parties. The council also subpoenaed two city employees who testified at an August 31st hearing of the Governmental Affairs Committee. That investigation brings us to the hearing today, where you will consider two charges against Mr. Joseph, who serves as the director of the Mayor's Office of Communication. Put in their simplest terms, the charges allege, first, that Mr. Joseph oversaw an advertising campaign intended to help the mayor's recall campaign, which violates state law. Second, that he lied to you about it. My presentation will cover three broad areas. First, just for sake of completeness of the record, I want to give you and the public some background on the process that led us to where we are today. Second, I want to walk through the charges and the factual basis for those charges and point you to the documents in the record that support the council's findings in that regard. And finally, since this is a legal proceeding of sorts, I want to talk about some of the legal terms that we're going to need to confront today and some of the legal standards that you'll apply. We begin with the Home Rule Charter, which of course divides power in this city between the executive and the legislative branches. Generally speaking, the mayor in the city of New Orleans is very powerful. We have what is called a strong mayor form of government. However, as a check on that executive power, the charter gives the council certain oversight authority. One piece of authority is the ability to conduct investigations. That was done in this case. The second important piece of oversight authority is the ability to remove executive branch officials when there are allegations of serious misconduct. I don't want to read the charter language to you ordinarily, but I think this is important. Home Rule Charter 3:125 says that the council may bring charges against any person appointed to the unclassified service for five things. That's a lack of qualifications, incompetence, neglect of duty, failure to comply with the lawful directive of the Civil Service Commission, or gross misconduct in reference to that person's duties. Charges are presented in writing to the appointing authority. The appointing authority has an opportunity to remove that employee. If the appointing authority does not do so, the council may hold a hearing at which the accused can appear and make their case. That is where we are today. If after the hearing, the council finds the unclassified appointee guilty as charged, the accused may be suspended or dismissed from the city service by an affirmative vote of the majority of the council. So what happened here? On September 12th, at the culmination of the investigation that I discussed, the council adopted motion number M23424, which brought two formal charges against Mr. Joseph in accordance with the charter section I just cited. On that same day, the written charges were provided to Mr. Joseph and his appointing authority, Mayor Latoya Cantrell. It said that if the mayor did not remove Mr. Joseph by September 15th, there would be a public hearing on October 3rd. As you recall, that hearing occurred at the request of the city attorney. We continued it until today. He was given time to produce a witness and exhibit list. That was not done. Just so we're all singing from the same hymnal today, I prepared a binder for the council's consideration today. Tab 1 is this presentation. Tab 2 is the motion that this council passed on September 12th. Tab 3 are the written exhibits that are appended to the motion. I have numbered them sequentially for ease of reference. Tab 4 is evidence of the notices that were provided to Mayor Cantrell and to Mr. Joseph. Finally, tab 5. As you recall, there was a hearing on August 31st that I referenced before the Governmental Affairs Committee. That is available online, but we have prepared a transcript of that hearing, and it is tab 5 of your binder. So let's get into the factual charges. Gregory Joseph is an unclassified appointee of the city of New Orleans. Just for the benefit of the public, employees in the city are either classified or unclassified. The overwhelming majority of folks are classified. That means they're protected by civil service rules. That includes police officers, firemen, clerical workers. A handful of employees are unclassified, typically high-ranking employees who oversee departments, who exercise discretion. Mr. Joseph, as the head of a department, is an unclassified appointee, and as such, he's subject to 3-125. He oversees an office of 6 employees. In his capacity as an employee, as the director of a department, he has a legal duty to comply with state and local laws, including the laws prohibiting the use of public funds in connection with electioneering, and we're going to talk about those. As the director of the Office of Communications, Mr. Joseph has the ultimate authority over communications and direct mail pieces that emanate from his office. Now, Mr. Joseph was hired last summer in around June or July. Shortly after that, as has been extensively documented, Mayor LaToya Cantrell found herself in the middle of a recall. On August 26th of last year, a formal petition was officially filed alleging a failure to execute the responsibilities of her office. Now, to prevail in that effort, state law required the recall proponents to get the signatures of 20% of the active registered voters in Orleans Parish, and the recall proponents had 180 days to do so. So the deadline to submit the signatures was on February 22nd of this year. Now, there was a bit of discussion during the August 21st meeting of the Governmental Affairs Committee. The recall was not ultimately decided until March because there was a period where folks could add or remove their names. Also, the registrar of voters had to certify names, but the real deadline, what everyone understood to be the deadline, was February 22nd, 2023. Now, a recall in the state of Louisiana is a very difficult thing to achieve. There's a reason why elected officials are not recalled regularly. If you consider the average voter turnout, getting 20% of the registered voters in the state to sign, or in a jurisdiction to sign and submit something, is a very tall order. So if you recall, when the recall initially happened, there was a lot of skepticism about its chances. However, the folks who were pushing the recall proved to be very resilient and very persistent. In late November of last year, thousands of New Orleans voters began to receive individualized mail petitions seeking to recall Mayor Cantrell, and they were underwritten by a well-funded supporter. And these recall petitions could be mailed at no charge back to the organizers who had submitted. And the practical effect of this step was that the possibility of a recall, which was remote and still remote, became much more real. And that was widely reported in the media. So how does that come into play here? Enter Mercury Public Affairs. Mercury Public Affairs is a multinational communications firm based in New York City. They're hired by businesses and by governments to prepare mail pieces of all types. 1 week after the individualized recall petitions began to be mailed to voters, we know that Mr. Joseph reached out to Mercury Public Affairs and let them know that he wanted to hire their services at the city of New Orleans. And we know this because there is an email that was produced in connection with the investigation in which one of the Mercury partners, a gentleman by the name of Jake Delamani, who we'll see later, he emailed one of his colleagues and said that the comms director for the mayor of NOLA, that's Mr. Joseph, called and wants a proposal from us. He wants us to get the business and hasn't gone to anyone else. 3 days later, on December 9th, 2022, Mercury provided the city with a proposal for direct mail services. In that document, Mercury proposed to, quote, work with Mayor Cantrell's team on developing comprehensive strategy to promote the current administration's successes and reinforce the positive citizen first directive voters gave the administration upon election. These are exhibits 1E and 1F attached to the motion that I mentioned earlier. And to be clear, Mr. Joseph, as the director of the Office of Communications, he was the one who directed the engagement of Mercury. He was the one who had the ultimate decision-making authority of the content of communications created by Mercury. Now, I want to be clear, there have been some comments raising concerns about the procurement of Mercury in this case. And from my view in the cheap seats, those concerns are valid ones. Mercury was selected with a no bid contract. There was no competitive selection. There was no DBE. There was no local hire. There were none of the procedural safeguards that we would expect in the selection of a vendor. And the selection of Mercury raises concerns that I think the council might be well to consider in future legislation, including the fact that the contract was originally valued at $30,000 and was then split across 2 years. And to date, I'm not aware that the contract with Mercury has ever even been signed, even though work commenced and was conducted. Those are serious concerns, but I want to be clear that this is not a case about procurement. Mr. Joseph is not solely responsible for the procurement of services, and the irregularities that are attached to this procurement do not form part of the charges against him. Now, Mr. Joseph's directive, this Mercury developed a one-page direct mail brochure that it was entitled City of New Orleans 2022 Recap. And at Mr. Joseph's direction, 106,000 copies of that mailer were printed and mailed to registered voters in the city in January of 2023. The cost to taxpayers was $50,000. That was for the printing alone. It doesn't encompass the cost to Mercury. We've yet to been able to find any evidence that Mercury has been paid for what it did. These costs, the costs that were actually incurred, however, were paid using public funds. We're going to get to the mailer and to some of the issues surrounding the mailer, but I want to take a step back to the law if I can. And I want to talk briefly about publicly funded electioneering. Article 11, Section 4 of the Louisiana Constitution prohibits the use of public funds to urge any elector to vote for or against any candidate or proposition. You can, however, use public funds to disseminate factual information relative to a proposition appearing on an election ballot. There's also a similar provision in the state election code, similar to what's in the state constitution. There's also another section of the revised statute, 43111.1, which says you can't send out an advertisement with a public official's name on it unless it's in furtherance of that official's public duties. The prohibition against publicly funded advertising certainly makes sense. However, it has caused a lot of consternation among local governments who want to make sure they don't get in trouble with the Attorney General, that they don't inadvertently commit a crime. So what commonly happens is that if a public official or a public body has concerns about the content of its mailer, it will first ask its lawyers. And if there is not clarity, they will often seek an opinion from the Attorney General about whether a particular mailer, particular set of factual circumstances is appropriate. And I want to highlight one of the opinions from the Attorney General because I think it really speaks to the issues here. On November 12th, 2008, the Attorney General issued opinion number 060119A, and it provided guidance about the rules that I'm talking about here. And the Attorney General talked about the distinction between the valid governmental function of informing the public and the prohibited function of public relations. The Attorney General noted that the key determination in whether a particular mailer is violative of the law or whether it's okay is the purpose and intent for which the funds are spent. It's the intent of the public agency or the official that makes the expenditure. If the intent is to simply to be factually informative, it's okay. If the intent is to manipulate public opinion, it is prohibited. Now, the Attorney General has not outlined a bright line rule. There's no absolute rule that says these are okay, these are not. There's a fake case by case factual determination that is made, and you look at the totality of the circumstances. You look at the timing. You also look at the frequency. And so if you had a door-to-door communication the day before election, that might be very problematic. That same door-to-door communication the day after might be okay. Mr. Joseph had a duty to comply with these laws. As a department head, he had a duty to ensure that communications from his office complied with applicable state and local law. However, in preparing the mailer that we are going to look at today, he did not seek the advice or input from the law department regarding the legality of the document, which is customary. Mr. Joseph claims to have relied on the expertise of Mercury in ensuring that the document was legally compliant. I will note, however, that the duty to comply with law remains with him. Moreover, Mercury is not based in Louisiana. It does not employ any licensed Louisiana attorneys, and on at least one occasion, as we see in Exhibit 1I to the motion, Mercury asked the city for guidance as to a matter of legal compliance. As I said, the key in determining whether a particular mailer violates the law, we need to look to the intent of the person sending it. And in this case, the mailer and the city's broader engagement with Mercury were intended to influence public perception and alter the trajectory of the recall campaign in violation of state law. And I want to talk about the evidence that supports that finding.
Yes.
First, let's look at the mailer itself. Now, although the mailer does contain some factual statements regarding city initiatives, the most prominent features of the mailer in terms of location, typeface, font consist of non-factual opinions and characterizations of Mayor Cantrell. Here we are. This is the mailer. It was a three-part mailer that folded. You see at the bottom right, strong leadership for a resilient city. That is an opinion, not a fact. The back, Mayor Cantrell has led the way in progress for our city. Again, an opinion, not a fact. Mayor Cantrell's opinion or image appears 6 times on the mailer. No other elected official in the city of New Orleans is featured. The words mayor, Mayor Cantrell, Mayor LaToya Cantrell are used 7 times. Again, no other elected or appointed official is mentioned. As I showed you, the front panel of the mailer pictures a picture of the mayor. Beneath that, strong leadership. We have other statements, and I think the most notable is the all caps, Mayor Cantrell has led the way for progress in our city. So when we look at the mailer, there are a number of things that would give rise to a conclusion that this is about the administration, about building it up. What other evidence is there? As I said, the Attorney General said that one of the key factors to be considered is timing. So let's talk about the timing. I think it's important to note at the outset that this is the first and only time that voters ever received an annual recap mailer since Mayor Cantrell assumed office in 2018. This was not an annual event. This was something that came out of the blue for the first time. And it was procured approximately 1 week after voters began receiving pre-filled recall petitions. Now, I told you that this case was not about the adequacy of the procurement process, but I would suggest to you that the speed with which this was procured is relevant to the intent behind the mail. Why the rush? Why was it so important to create a purely educational mailer that we had to entirely disregard competitive selection processes, to circumvent the DBE rules, to ignore local hires, just to get a vendor in place so that we could give folks an annual recap, which we had never done before? Now, the original proposal sent by Mercury and this goes again to timing, contemplated a series of not one, but 12 direct mail pieces. The first mailer was scheduled for distribution in December of 2022. The last was scheduled for February 16th, 1 week before the deadline to submit signatures in the Cantrell recall. And I want to show you a page from the Mercury proposal. There it is. This is the planned schedule of releases. First, December 28th, the last drop date, that's when you put it in the mail, February 16th. Now, I will note as to the severity of this violation, only one mailer was ultimately sent at a cost of $50,000. But the plan here was to send 12, which would have been a cost of $600,000 to taxpayers. Let's keep talking about timing. Proposed term of the contract with Mercury. As I said, it was never signed. It was ultimately changed, but the original term of the contract with Mercury began on December 9th, 2022, and ended on February 22nd, 2023. You will remember that as the exact day of the recall petition deadline. They overlap exactly. The intended term of the Mercury engagement that didn't come from the folks in the procurement department or finance. That was dictated by Mr. Joseph, and we know that from the exhibit appended to the motion that the council passed. That's an email from Mr. Joseph to Brianna Bradley. When the Office of Communication procured this, they had to reach out to the CAO and get his approval. So they were submitting those documents. Ms. Bradley says, hey, we need the info regarding the contract length and the amount that the contract is supposed to be. Mr. Joseph supplied that, $30,000 to end on the day the recall ended. Further evidence of the purpose here and the intent behind this mail campaign comes in the form of what was planned but not sent. The city emails that were exchanged during the development of this mailer highlight that the purpose of this was political, not educational. And I want to focus you on a January email from a communications office employee, and I want you to look at some of the topics that were proposed and considered and being discussed as planned mail pieces. Again, we're still trying to comply with the February 22nd recall deadline, but some of the mailers we were talking about include crisis mayor, problem solver, and historic nature of election. 5 years into a mayoral term, what could possibly be the educational benefit of reminding voters of the historic nature of Mayor LaToya Cantrell's election? Certainly important, but relevant only to her recall and bolstering support. In addition to what the mailer said, when it was sent, what else was planned, we also need to look at who got the mail. Political motives are evident here as well. The mailer was only sent to registered voters who voted in the last 2 odd-year municipal elections, which puts them squarely in the group of active registered voters who are the eligible participants in the recall campaign. Mr. Joseph was not a passive participant in this process. He also contributed, and I've attached a screenshot of Exhibit 1N to the motion, and that's a conversation between Mr. Joseph and the folks in Mercury where they're talking about how to get voters 35 and under into the pool of recipients. Again, the purpose here was political. If the desire is to inform citizens and to be purely educational, folks who aren't registered to vote have the same interest in safe streets as those who are. Finally, there is direct eyewitness evidence that Mr. Joseph conceived of the mailer as a public relations piece intended to influence the recall. As I said, the August 31st, 2023 meeting of the Council Governmental Affairs Committee, we heard testimony from the city's chief procurement officer, Mr. Julian Meyer. He would say Mayor, but Meyer. Councilmember Harris asked him a question. Did anybody describe to you the content of the mailer? Mr. Meyer, no. Did anyone describe to you the purpose of the consultant? I was just told this in the context of the recall. If you were there at the hearing, that was the point at which there was an audible gasp from the folks in the room. Now, we might debate whether in the context of a recall is the same thing as I was told it had to do with the recall. However, later in the meeting, Councilmember Morrell circled back and closed the loop. Councilmember Morrell asked Mr. Meyer point blank, you mentioned previously that there was a mention of the recall at the meeting. Do you know who made that mention? Said that only you, Mr. White, Mr. Joseph were in the meeting. Obviously, you didn't bring up the recall. You don't remember contextually who brought up the mailer in the context of the recall? I don't recall. It was either Mr. White or Mr. Joseph? Yes. They were both in the same room at the same time with you? Yes. Where we talked about the advice that was given? Yes. Mr. Joseph or Mr. Meyer was given a chance to clarify himself, to say that there was no mention made of the recall. Instead, he clearly testified that they were talking about it in a meeting with Mr. Joseph and Norman White, the Director of Finance. Finally, there were contemporaneous text messages from the folks at Mercury that support the conclusion that they too understood the urgency created by the recall. On February 27th, that was 5 days after the recall had ended, Mr. Delamonte sent Mr. Joseph a voicemail following up on the initial mailers. In that voicemail, he states, quote, the time restrictions are no longer relevant here, so I know additional mailers are not time sensitive. The only plausible cause of time sensitivity at this point in time was the recall itself. And tellingly, once the recall failed, the planned educational mailers, the additional 11, stopped. They weren't completed. We will get into it when I walk through the charges, but there was an allegation that Mr. Joseph was not candid to the council during his testimony. During his sworn testimony, he had a legal duty to testify honestly and truthfully, and that duty is important because the very reason for his testimony was that the council was exercising its authority over the executive branch, its supervisory authority. Mr. Joseph testified under oath that the direct mail campaign, or he denied under oath that the direct mail campaign was related to the recall. And as I pointed out to you, that testimony was contradicted by Mr. Meyer. And I put them side by side just so that we can see. Mr. Joseph was unequivocal. You had no thought in your head to solicit this proposal and send out this mailer because there was a recall happening. No, absolutely not. Mr. Meyer, did anyone describe to you the purpose of the consultant? I was just told this in the context of the recall. Two charges against Mr. Joseph today. Charge number one. Gregory Joseph did intentionally institute, participate in, and oversee a publicly funded advertising campaign intended to garner support for Mayor Cantrell and to sway the outcome of the recall in direct violation of state law. His actions in that regard constitute incompetence, neglect of duty, and gross misconduct. Charge two. Gregory Joseph did intentionally provide false testimony under oath before the Council Governmental Affairs Committee on August 31st, 2023 regarding the role of the recall campaign in connection with the City of New Orleans 2022 mailer campaign. In the face of a clear legal duty to tell the truth and to cooperate with a lawful investigation of the City Council, Mr. Joseph's misrepresentations constitute incompetence, neglect of duty, and gross misconduct. Now, I read you two charges. I want, just so we're all again singing from the same hymnal, I want to walk through those legal terms just so that we all have a clear understanding of what we're talking about today. The first thing with which Mr. Joseph has been charged is incompetence. That is the state or fact of being unable or unqualified to do something. And I should note that the charter doesn't define these terms. And so when a term isn't defined in the law, we look to legal dictionaries, we look to case law, we look to the kind of common tools that lawyers use to understand these terms. So Black's Law Dictionary gives us a definition for incompetence, and I've tried to put some meat on that bones by giving you some language from an old case, but I think it provides a pretty useful definition of incompetence. When you research the law of removal for incompetence, you typically see it in connection with cases involving teachers, because incompetence is one of the grounds for removal of a tenured educator. Incompetency as a ground for suspension and removal has reference to any physical, moral, or intellectual quality, the lack of which incapacitates one to perform the duties of his office. Incompetency may arise from gross ignorance of official duties or gross carelessness in the discharge of them. It may also arise from lack of judgment and discretion, or from a serious physical or mental defect not present at the time of election, though we do not imply that all physical and mental defects so arising would give grounds for suspension. Just in terms of how this has been applied by the handful of courts that have addressed this, as you might expect, as the conduct becomes more serious, a finding of an incompetence becomes easier. So there are cases where you have trivial instances of misconduct, or small kind of acts of or incompetence, not misconduct, small acts immediately corrected. Those have typically been found not to constitute actionable incompetence. However, there are cases in which a single deliberate instance of willful noncompliance has been sufficient to support a finding of incompetence. Neglect of duty. Neglect is the omission of proper attention to a person or thing, whether inadvertent, negligent, or willful. Duty is a legal obligation that is owed or due to another that needs to be satisfied. And I have outlined for you the duties that Mr. Joseph had: to tell the truth to the council, to comply with law. As an example of when neglect of duty is sufficient to support removal, I want to point you to a case, Freeman Durrell, and we actually talked about this in connection with a removal of a Hano commissioner that we dealt with. Misconduct is grounds for removal of a Hano commissioner or any housing commissioner. And there's a case arising from the Third Circuit, relatively recent, where you had some housing commissioners who voted to go into they went into executive session without voting to do so. And that's a violation of the state open meetings law. Just as a kind of how courts view these, a single instance of noncompliance with the law was found sufficient to sustain removal. One instance of noncompliance with the open meetings law. Now, that doesn't mean you have to, but the court reviewing that and what the folks who removed the commissioner did said that that was enough. Finally, gross misconduct. Misconduct is a dereliction of duty, unlawful or improper behavior. Gross misconduct, as the name suggests, is more serious. It's conduct that was willed and intentional. It's more than conduct which comes about by reason of error, judgment, or lack of diligence. It involves intentional wrongdoing or total lack of concern for one's conduct. Whether or not an act constitutes misconduct must be determined from the facts surrounding the act, the nature of the act, the intention of the actor. Gross is generally defined as flagrant and extreme. Since we have an allegation as part of the charges here that Mr. Joseph was not candid with the council when it was overseeing the executive branch pursuant to its investigatory authority, I just wanted to highlight for you a case, In re King, in which the Louisiana Supreme Court held that lying to the Judiciary Commission in a sworn statement constituted willful misconduct sufficient to justify removal of an elected judge from the bench. We're not talking about an appointed official. We are talking about someone who voters put into office. A single instance of lying to the Judiciary Commission, which is the body charged with investigating and overseeing judicial misconduct, much as this body is charged with overseeing misconduct by the executive branch, was sufficient to remove a judge. Burden of proof. Now, the charter does not specifically give us a burden of proof that we need to follow today to remove someone under 3-125. It uses the term guilty, but this is not a criminal proceeding. This is a legislative matter. So we're not talking about a reasonable doubt standard of proof. Generally speaking, the rule is when there is no stated burden of proof or standard of review, your actions are reviewed under an arbitrary and capricious standard. Now, the arbitrary and capricious standard is easier to say and sometimes kind of tricky to apply, but I will tell you what the courts say. A decision is capricious, which is bad. When one, there is no substantial evidence to support it. Two, when it's contrary to substantiated competent evidence. A decision is arbitrary when it disregards the evidence or the proper weight thereof. And while we're talking about evidence, evidence can be direct or circumstantial. Direct evidence is proof of the existence of fact, usually in the form of a document or an eyewitness testimony. In this case, we have the eyewitness testimony of Mr. Meyer. We also have a lot of documents that would generally constitute circumstantial evidence. So circumstantial evidence tends to prove related facts from which you can apply reason and common sense and conclude that a fact is to be true. Even though in this case we do have direct evidence, just so you understand the kind of how a court might view whatever you ultimately do, circumstantial evidence by itself can be sufficient to support a decision of one party in a judicial proceeding. It doesn't have to eliminate every possibility, but it has to exclude every other reasonable hypothesis with a fair amount of certainty. And just by way of background, when you have a case that involves intent, as this one does, it's very rare to have an absolute smoking gun where you have an admission on paper. And if that were the case, the folks who would only the truly inept would ever go to jail for fraud or ever be engaged in fraud. Typically what courts, fact finders, juries do, they make reasonable inferences from the evidence. And finally, in a case where you have conflicting testimony, which I would submit we do here, you're not hopelessly bound by the conflict. The trier of fact can make a credibility determination and may, within the bounds of rationality, accept or reject the testimony of every witness or any witness. And that is based on your observations of their demeanor. Were they forthright? Were they hostile? Were they biased? And that brings me just about to the conclusion of my presentation, and I thank you for listening. Just in closing, I would like to echo Councilmember Morell's remarks that being here in this capacity today gives me no pleasure as a public servant, and it does not please me to be in a position to articulate charges against a fellow public employee. And I also do not envy the council the very difficult task of weighing this evidence and of reaching a conclusion. However, while the task of removing an appointee may be difficult, the evidence in this case, I would submit, is not difficult at all. It is very clear. Gregory Joseph tried to help out his boss with a PR campaign that was intended to help her struggling political prospects. It was political at the inception. It was political in its execution. I don't know how you begin to deny what seems to be clear from all the evidence we have seen. He could have found that out by asking the law department. He didn't. And I don't know why. I don't know why he disregarded the law. Why? But he should have known. He should have known that the conduct was improper, and he had a duty to know. He has made no attempt to explain, and to my knowledge is not here today, his conduct. And this matter may have been different had he done so. Had he said, "I'm sorry," or "it was a mistake," or "I could have asked," but he didn't. And that is perhaps predictable considering the politics of the age in which we live, when saying you're sorry or you are wrong is viewed as a sign of weakness. Would have been nice had he done that. But even if we can't expect our leaders to be contrite, we do have the right to demand that they be candid, that they be honest with us. And once again, the evidence in this case is very clear that he was not. He was subpoenaed to testify. He had a duty to tell the truth, and he didn't tell the truth.
Why didn't you investigate it fully though?
Even if the mailer is a small issue, the failure to tell the truth about it, that is a big problem. And truth matters. Honesty matters. Integrity matters, and they matter in this building. And the task of finding the truth is not a waste of this council's time. It's not a waste of my tax dollars. And if you have any questions, I will answer them. Otherwise, turn my
Madam,
time over
we
to the
may
administrator.
ask you to go over the actual motion we'll be voting on. But before we do that, why don't we allow public comment? And then we'll allow some closing statements, then you can read the charges of the motion that we'll be considering today. So for public comment, I have 2 cards. If there are more people who'd like to submit cards, please do so at this time, because I do want to give everyone here who would like to speak an opportunity to do so. First up, we have Mr. Cole.
Thank you.
Oh, and just to be clear, for 3 minutes,
Thank you, sir.
you're welcome.
So I didn't even know I was gonna say this today. Dereliction of duty and the other charge that he had against the gentleman, I know a lot about those. That's how I got out of the United States military. Precacious and adverse, I learned those terms in the same hearing. And what I had been accused of doing, I was actually doing. I would hold muster and then go hide and play cards with my friends, right? And when we got caught, I took the charge. They went and got the PM3 above me, and they went and got the Black Master Chief above me, got all of them for accountability. We have an administration that preaches accountability when it comes to citizens and indigenous. And all of this is a kangaroo court for the simple fact that there's no way that all of the expenditures and all of the discretion was yielded without LaToya knowing directly that it was happening. Why aren't these allegations being brought to where the discretion was wielded? That's the first thing that we want to know. And we want to also discuss the fact that you guys are selective and how you're dealing with what's going on in our city. First, let me jump off. Leslie, you're very intelligent. Really, you're very intelligent. I tried to find, I can't find nothing. I'm saying you're evenly killed. I appreciate that. I wish I could talk to your dad. When I knew him to sit here, he didn't play the games about accountability, man. You can't do that and hold that name. And I just talked to your daddy, JP. No disrespect to you, you're an adult. I just talked to your daddy about suffrage, about what he and my mom and the rest of the people who stood when we were nothing here to get where you can sit there, where y'all can sit there, you minorities, right? And so, man, we just want to see accountability from y'all. That's all, really. This is a kangaroo court. We can fire this black man. He needs to go for lying. The second charge he's guilty of. The first one he's not. LaToya constructed this. We know this. She's done what she wanted to do. Oliver, I want to tell you something, because somebody that loves my mama and her friends that are related to you called me and asked me to say to you, people don't know I love you even though we fight. Man, focus on the East, man. You shouldn't have been at Byron Lee's meeting. It's a bad look. My DM's full. They want me to disrespect you for that. But I'm just going to remind you, since we come from the same camp, that we can't identify you sometimes, man. And Eugene, I'm coming to get your job.
All right.
I'll see you at the next election.
Looking forward. Thank you, Mr. Cole. Next up, we have Mr. Keith Hudson. And after Mr. Hudson, we have Mr. Morgan. Mr. Morgan, after Mr. Hudson, it's your turn. Go ahead, Mr. Hudson.
Good morning. Name's Keith Hudson, Time for a Change. When I saw this, what you call it, witch hunt on Mr. Gregory Jones, the first thing came to my mind. Many times I've been to court, got accused of something I never done, but I spent time in jail for it. And I look at the fact that when you engage in war, the first thing you do is attack the communication. Mr. J.P. Morrell and Mr. Gregory is LaToya Communications Director. And if he did anything wrong, she had to sign off on it. And you circumvent the law to tell it to fit your attack. Number one, you said LaToya didn't have no knowledge of what Mr. Gregory was doing. That's dodging the bullet for the boss. And you know as well as I know, and everybody on this council know, Mr. Gregory couldn't do anything without LaToya's signature. That's number one. Number two is, where was his energy when your brother got a letter from the FBI? Where was this energy then? You can conjure up all these old laws that never been used before, but you can use them and get this guy to cite laws and all that. They do that all the time in Tulane and Broad. Number three, the feds, where was his energy when Officer Vachi, that's his name, Vappy? He committed so many crimes dealing with LaToya contract. Where was this energy at then? We looking at you holding a personal war against the mayor office for political aspiration, man. And that's wasted energy. Where was this energy when this council gave the New Orleans Police Department Retention Committee $900,000 to do a video with a man in hot pants shaking his ass? Where was this energy at then?
Oh, damn.
Where was it?
I saw that ad.
We talking about kangaroo court. All the poor people have been through it. I done been through it several times. When I see it, I identify with it. This BS. Because Mr. Gregory, everybody on this council knows Mr. Gregory can't do nothing without authorization, man. Come on. And y'all playing games. I don't see how one city council can always be in front of the news and then got 6 more y'all don't say nothing. That's politics.
Only 3 of them listen.
And we got to stop this, man, because this war with J.P. Morrell for mayor, he want to be mayor.
No, he doesn't.
Plain and simple. Thank you.
Next up.
It's Elena that he's trying to get to be the mayor. It ain't JP.
Thank you, Mr. Morgan.
Good morning to everybody in the council. I'm here on the behalf of the people of South, East, and West of NOLA. They ask that Mr. Joseph be dismissed today. The trust of him was in the people. He deceived the people. He lied to the people. But like I heard them say a couple of minutes ago from different ones, Cottrell knew about it.
Yes.
And when she knew about it, Cottrell is a master tricker and a master liar.
Yes,
She know how to play down any subject, anything. You come up with it, she'll play it down. The people ask you, please to fire her, Mr. Joseph. And Cottrell, she is responsible for the city is in the condition that is in now. You, Oliver Thomas, you was very faithful and loyal to Cottrell. But when you asked for help for the East. The 7 million or whatever it was, she turned you down, but you was faithful. You, Eugene, when I thought and lost hope in you, you showed me that there was hope, and I believe in you. J.P. Morrell, you're a hell of a person, man. Orlando, my council, the president, you fought many battles in this council for the people, and you was always there. King, you showed me, King, you showed me that when you write, that you will come aboard and support the people. You showed me, oh yeah, I admire you and I respect you, that you hold a position that you don't play favoritism, you for the people. And Joe, you showed me that if I think right, and if I'm right of what I thought, you had educated the group and you brought them to a level where they could serve the people if only they will all come together. You all could be the most hell-fired council that the city has ever had, because I have never seen a group that is fully concerned about the need of the people. Yes, I have came in this council, many years and many days, and I have seen a change. But today I ask
One of the worst councils
that
we've ever had.
you will fire Joseph, and the mayor, don't underestimate her. Like he said, she knew about this. She concocted this. She put it together, and everybody that she appointed.
But y'all ain't saying
And-
shit.
and-
The standards are gonna stop. JP, cause he kissing your ass, you ignoring the red. What's up? What's up? What a standard?
But
Come on, what's happening?
I
What's
never,
happening, JP?
I never,
What's happening, JP?
I never interrupted.
Mr. Cole,
I
Mr.
never,
Cole,
I never interrupted.
Mr. Cole, no one interrupted you.
I never
No one interrupted you.
I never, I never interrupted.
See, y'all, because they be on record, because they be female, y'all think I'm not gonna say that.
Hold on, man, give me respect, give me respect. I give
I
you
want the
respect.
same respect they
I
give
give you
you.
respect.
I wanted it at 52.
You're right.
Yeah, what you done? What you done? You up there kissing their ass, and that's why
He's not.
No, if he can talk, I can talk. It's rated.
He's gonna keep talking as long as you can.
Who you gonna put out? We both in the wrong. Who you gonna put out? We both in the wrong.
I didn't.
Mr. Morgan, please finish up. Mr. Morgan, please finish up.
We both in the wrong.
But sad part about it, you understand?
Listen to me,
Respect.
We're not doing that.
Respect.
We're not doing that.
I
We're
respect.
not using this form for that.
Thank you, Mr.
We're
Morgan.
not using this form for that.
Thank you,
We're
Mr.
not
Morgan.
using this. You had an order, it was red.
No, I don't.
Thank you,
There you go.
Thank you, Mr. Morgan.
It was red.
Favoritism.
Me neither.
Every council on.
That's what you're trying to start now.
You got a personal vendetta.
I ain't got no personal vendetta. I got 3 friends up there. Ain't a family member.
But you.
What you talking about? I don't got no personal vendetta.
And the saddest.
I don't got no personal vendetta. This is about checks and balances.
You don't know how.
Checks and balances.
Reality. and-
Checks and balances.
Thank you, Mr. Morgan. Next up, Mr. Parker.
You've been read.
Mr. Parker.
As long as you talk, I stopped when my time was up. I stopped when my time was up. I stopped when my time was up. You were the one being disrespectful. I stopped when my time was up. We gonna make us listen to you kiss their ass. Shut your mind, old man.
Edward Parker,
Get to a rocking chair.
7802 Henley, New Orleans, Louisiana, 70126. Also a member of New Orleans United Front. We've been here before, and we've complimented you guys. This council is the most progressive council, and I'm 79 years old myself.
I've been before this council many times
For political motive.
about different.
Elena Moreno ain't said shit that my mama didn't say, I didn't say. Tony ain't
All right.
say,
Mr. Cole, Mr. Cole,
Stay
Mr.
at
Cole, this is your warning. Everybody gave you the time, everybody let you speak. When you spoke,
You can't get my money from my fucking document, so. Y'all put the shit, I'm not gonna get exposed, man.
I went to jail the last time.
Talk to your daddy, you need to call him. And talk to your daddy, bro. It's acting like a fucking bitch.
all right, Mr. Parker, go ahead.
That's not democracy. Okay, let's get back to what democracy is all about. Thank you, council, for what you guys have done. I'll start all over again by saying this council, in our opinion, is one of the best councils that we've had in years. You guys are independent. You show your independence. Vice President Elena Moreno and President Morrell, you guys are supposed to lead the council. That's the way the charter is supposed to be run. So thank you for what you guys have done. Just do the right thing. This man lied. Not only did he lie, he also tried to cover up. He needs to go. Plain and simple as that. Let's keep this city on a positive track. Thank you.
Thank you, Mr. Parker. W.C. Johnson, followed by Ricky Peterson.
W.C. Johnson, Community United for Change. I want to thank you for laying out the charges, and I guess it's obvious and evident that he's guilty as charged, so shouldn't be a whole lot of fanfare from there. The brother just said that you guys are independent. We'll find out how independent you are on Thursday. Now, the people gave you this power. And we want you to not only respect the power, but to understand that you are charged by the people to do the people's bidding. Not special interests, but the people's bidding. So I commend you for taking this on and doing what you've done thus far. And I just ask that you continue to weigh what the public wants and where they stand as you have in the past. Thank you very much.
Thank you. Mr. Pearson, followed by Mr. Bayet.
Good morning, Ricky Peterson, resident of New Orleans East. And to the council that gave the presentation, you did a good job of telling a story, your version of a story. It doesn't make it true, doesn't make it factual. It makes it your opinion of what happened. And you had some rules about the law and intent. Also, again, your opinion. But you weren't here to persuade a jury. Because if I was a member of that jury, I would vote not to take the action that I know this council's always have to take. Because everything you said was complete and utter bullshit. Everything. Nothing factual about it. Mr. Joseph, and you can correct me if I'm wrong, but Mr. Joseph did not write any contract. He did not force anybody to circumvent the law. Whatever action was taken by parties, individual parties, lawyers like yourself, who may work under you, but the lawyer who wrote the contract, he did that independently of his own free will. Where's that lawyer? Why is his job in jeopardy? Why is it just this one person job being sought after? when it was clearly, if an action like this was taken, and it was clearly factual, as you want me to believe, and I'm no fool, if you want me to believe that it's factual, you should have, this council, Mr. Morrell, should have called more than just Joseph Gregory to answer these charges. There should have been more. The procurement director should be charged. Should be after his job. He gave the advice to circumvent the process. Why isn't his job on the line? It's because he came in here and somewhat placated to you, J.P. Morrell? It's because he somewhat answered your guided questions to Mr. DeRusso to get the response for you to elicit the response from him that you wanted? Or was it because you, Leslie Harris, who was busy looking at your phone? I'm sorry, I don't know about it. You can continue to do what you were doing. What was it about him that made you decide not to ask for his job? When he admitted to you, it was his advice to circumvent the process. He gave them, it was his idea. That's what they went to him for. But he's not here. His job isn't on the line. Only one person's job is online. And maybe it's because it's a vendetta being carried out by you. Between the history with your mother that said on the council. You know, with things that she's done. Was it why your brothers enjoyed the perks of the patrolling, the fairgrounds, because in order that she passed. I know my time is up. That's all I wanted to say.
Thank you. Last up, we have Mr. Baya.
Gary Ballier, New Orleans United Front. I want to thank the council for exercising its power. Finally, we can see government in action, checks and balances in play. I'm glad to see that you went after somebody who obviously misused our money. A simple printing contract to a local printer could have put out information. We found an international firm that does public relations, communications to promote somebody to do this job. Could have cost a lot less. We could have gave it to Universal Printing. I'm pretty sure at a fraction of this cost. All we want as citizens is people to be, you people, the elected officials, to be good stewards of our money. And I'm pretty sure if you look a little further, and I'm probably find in every city department, every city agency, similar things have happened. So I want to continue to see the council exercise its power and its judgment in bringing things to light. Because this isn't the only case, the Mr. Joseph case, and I agree. And some other things were brought up here about some other instances where things should have been looked into. And I think you should. And at the public request, if we actually look into something, you should look into it and see if it has any merit. Thank you for using the power and authority given to you by the charter. And we hope this continue with this council and future councils. We appreciate it. Thank you.
Thank you, Mr. Baya. At this point, Adam, can you go over the motion that we'll be considering today?
Certainly, Councilmember. After you've made individual comments, if you elect to do so, the clerk will take 6 votes. So there are 2 charges, and as to each charge, Mr. Joseph is charged with incompetence, neglect of duty, and misconduct. So as to each charge, each element of that charge, we will take 6 votes, if that makes sense. And the clerk will read it, she will explain what the vote means. If the council votes yes on any of the 6 charges and finds Mr. Joseph guilty, at that point, it would be appropriate if any council member decides to bring a motion either to remove Mr. Joseph from the city service or to suspend Mr. Joseph from the city service. Either of those options is available under the charter if he is found guilty. But step 1, the clerk needs to read, she has a script, I believe, of the kind of individual charges, take those votes, and if any is yes, then you can consider the appropriate sanction.
Thank you. Does anyone wish to make any closing comments? Councilman Thomas.
Yeah, first of all, I want to thank everyone who participated in this hearing. You know, as someone who's been part of 5 different councils and who understands a little bit about the charter and the law and the rules and the separation of government. Respect of authority, respect of individual institutions is extremely important. It's bigger than me. It's bigger than our individual personalities. And I never forget Jim Singleton talking about, you may not like the individual. You may like the issues that bring you before the body, but you're supposed to respect the body. For folk who know me and a little bit about me, I came here ready to exonerate or not vote to remove Mr. Joseph, but I came here to hear that from him, or hear that from him and his attorney. I came here to hear an opportunity where he could refute or rebut any charges and give other examples of why many of the things that have been levied against him are not true. But you have to respect the institutions that govern us, even if you don't like the individuals. And I respect Mr. Peterson's position, but I was hoping that he would come here and say, he would say why these charges were false and why they don't apply. But I was not afforded the opportunity to do that. I'm also extremely conscious of the fact that, and for folk need to know, to move forward with the removal of this man, one of the highest groups of unemployment in this community are Black men. And does that apply here? No, but I'm always conscious of what affects our culture and our community individually. So it's disappointing to me that I didn't have a case counter to the one that was presented by Adam. And let me say this about Adam Swensick. I've worked with a lot of people who worked with and for us. I don't know anyone, I've met very few people that exhibit the kind of care and integrity and principles that he's done in his job. So the fact that he laid out a case and laid out recommendations, and we didn't have a counter to those recommendations, weighs extremely heavily with me. Thank you.
Councilman Green and then Councilman Druce. I came here today also looking forward to hearing opposition, if you would, to what the council's evidence showed. I also will tell you that I'm a bit disappointed, and I'll use that word because there are so many ways to communicate with the council, to communicate at our meetings, to communicate with us by email. There are also processes that involve maybe the city attorney or courts, for example, if you felt that what was not going forward was the right thing to do. And more than anything else is a disappointment because I too came here very open-minded relative to hearing, because honestly, I have concerns as to whether or not a recall campaign is the type election that the Attorney General was referring to, or proposition. I have concerns. I did always have the concern that I felt that public bid laws were violated. I think that's pretty clear that that was the case. But I wanted to hear more of the other side of relative to the recall campaign itself. So this lack of our witness, or if you will, the defendant, and if I'm wrong on the technical term, if he's not a defendant, you know, please just correct me after the fact, or the accused. I wanted to hear more. And unfortunately, this meeting is a lack of response to a council schedule, which I thought was relatively fair, especially since we granted an additional 2 weeks. If it was not possible, for example, for Mr. Joseph to have gotten counsel during the last 2 weeks, I was open to hearing about that. But we hear nothing. We don't have any correspondence right now. And I'll just leave it at that, and I'll look forward to the vote. Councilman Druce, then Councilman King.
I think we're all singing from the same sheet of music today, because I literally wrote down here, we are acting somewhat as a tribunal today, so that means we want to hear evidence from everybody. And so far, the only thing that Mr. Joseph provided is when he sat here several weeks ago. I wanted to hear whether there are other witnesses who could rebut anything that was said. I wanted to know if there were other emails that we hadn't focused on. I wanted to know if there were other contracts or other invoices with which we were unfamiliar. I wanted to see if he had made a claim for indemnity against Mercury for saying that they were responsible for what happened. All I'm left with is the mountain of evidence Mr. Swinzik provided and no statement other than his testimony. And putting aside respect, lack of respect, if we're going to balance, the scales have been tipped one way as opposed to the other. Thank you.
Councilmember King.
Sure. Well, I want to first say, thank you, Mr. Swinson, for the job that you've done, that you did putting this presentation together. I think Mr. Joseph not showing here, shows a lack of respect towards his council and towards the people of the city. Especially after he showed up last week, during the confirmation hearing for an interim Superintendent Kirkpatrick. I know for a fact that members of this council has reached out to the administration to resolve this. And those conversations got nowhere. So this council did try to resolve this before it got to this point. And I just think overall that Mr. Joseph is being openly defiant and disrespectful again to this council, to the people of this city. And we just can't have that. And I'm much like Councilman Thomas, very conscious about advocating or taking a person's job, especially a Black man's job. But Mr. Joseph at this point has pretty much left us with no option by saying, I'm not gonna show up. He gave me 2 weeks. I refused to show, even when I came here last week, but something that had nothing to do with me. So clearly he can show when he wants to. I just think I'm just disappointed in his actions. And if somebody above him is guiding him, I'm equally disappointed. That's my comments.
Are there any other comments? I'll give my brief comment and then we'll go to the clerk reading the individual charges. I think it's beyond dispute. The evidence today is overwhelming. I know that there have been a lot of people who've had opinions on who should or should not have been before us today, but this council came to this moment today because it is where the evidence that was available led us. If anything, I think that you could see the fact that this was not a witch hunt, as it was said previously, to target multiple officials. It was an investigation that narrowed the focus, like it does in an investigation, to the individual where the evidence was overwhelming and astounding. I will reiterate what our attorney, Mr. Swinzik, said. There is a problem with procurement. The fact that this procurement was above the amount, wasn't properly procured, then reduced, that is an issue, and it is an issue that council will address separately through ordinances, because it is evident at this point that there is a significant problem with procurement under $15,000. It is unchecked, it is unrecorded, it is untracked, and it has to be resolved. We've heard through the course of this investigation many concerns by groups of people regarding conflict between the council and administration, as well as some people have tried to discount the amount of money that's in play. I'll begin by saying for anyone in the city of New Orleans, $50,000 is not a small amount of money. It is a large amount of money, a large amount of taxpayer dollars. And I've spoken to people throughout the city, whether they oppose the recall or were for the recall, they all said, I didn't want my tax dollars spent regarding the recall. I will tell you personally, and this could be me as an attorney, when you confront someone with something that is wrong and they will not acknowledge that what they did was wrong, what history has told us is it'll happen again. And there is a precedent that has been set, that has been established by Mr. Joseph, that somehow it is allowable in this city to waste taxpayer dollars on a political mailer. And it is equally important when we make these considerations today, we must crush this precedent. We do not need any mayor, any communications director for the future of the city to be spending taxpayer dollars on political mailers. As Mr. Swinzik said previously, This could have been avoided if he just would have asked the city attorney, can I do this? And if anything, we saw from one email that wasn't referenced, after the fact, when he asked the city attorney, is this permissible? The attorney said no. But to quote Mr. Joseph in a paraphrase, the mailer was already in the mail. So I think it's equally important to send a message that this administration and future administrations follow the law. And if you don't know, talk to the city attorney, because underneath all of this, what drove me most today to have this moment is, and I know one of my friends out in the audience says this all the time, I take the term Big Easy as a slur. I always have. I think the idea that New Orleans is the Big Easy, that we are this laissez-faire city where anything is permissible, has gotten us to this point. The city has a reputation of looking away when people do things that are wrong, especially when the city has the authority and the obligation to correct it. We have seen the Sewage and Water Board have individuals manipulating plumbing contracts for profit. We have seen multiple administrations use complex technology contracts to either defraud the city or attempt to do so. And more importantly, in recent memory, we have seen inspection officials fail to inspect and a building fall on people. So when people say, what's the big deal? The fact that people don't think this is a big deal, the fact that we had to come to this point, ladies and gentlemen, the council doesn't want to be here today. We sent these charges to the administration to terminate Mr. Joseph so we would not have to be here. We are here because no one else would act, and we are the last line. So I think it's important for us to do what is necessary to restore faith and confidence of the public, that when people in the Big Easy don't do their job or do their job in a way that insults the conscience and honestly the intelligence of the public and the council, we have to do the right thing. Those are my comments. Madam Clerk, please read the charges.
Council members, we will now vote individually on each of the grounds for removal set forth in each charge alleged in motion M23-424. Number one, as to charge one in motion number M23-424, namely that Gregory Joseph did intentionally institute, participate in, and oversee a publicly funded advertising campaign intended to garner public support for Mayor Cantrell and to sway the outcome of the recall effort in direct violation of state law. Does the council find Gregory Joseph guilty of incompetence sufficient to support his suspension or removal from the city service? A yea vote is guilty, a nay vote is not guilty.
And this relates to incompetence, correct? That charge, that particular charge, right?
Yes, sir.
Okay.
Since you read the charge, is we required to make a motion, or we have to do it by voice affirmation to go quicker?
Adam.
Voice affirmation. Okay, so the charge has been concluded. Please indicate your vote by voice acclamation. Aye.
Aye. On incompetence, nay.
Okay.
Do you want to do a call?
You went.
Wait.
Why don't we do by roll?
Please, because, yeah.
Well, the machine is not. It's not working. I don't think Granicus operates in a non-motion mechanism. Why don't we just go do roll call, and that would be easier.
Just let me, okay.
Yeah. Do roll call. That's
All right.
fine.
Councilmember Thomas.
Hey.
Councilmember Green.
Aye.
Councilmember Morrell.
Yay.
Councilmember Moreno. Yay. Councilmember King. What did you say?
Yay.
Councilmember Harris. Yay. And Councilmember Jeruso.
Aye.
We have 6 yeas, no, and 1 nay. The next one. As to charge one, does the council find Gregory Joseph guilty of neglect of duty sufficient to support his suspension or removal from the city service? A yea vote is guilty, a nay vote is not guilty. Councilmember Thomas,
Yay.
Councilmember Green,
Yay.
Councilmember Morel,
Yay.
Councilmember Moreno.
Yes.
Councilmember King,
Yes.
Councilmember Harris.
Yay.
Councilmember Jeruso.
Yay.
We have 7 yeas. Number 3, as to the charge 1, does the council find Gregory Joseph guilty of gross misconduct in reference to his duties sufficient to support his suspension or removal from the city service? A yea vote is guilty, a nay vote is not guilty. Councilmember Thomas?
Yay.
Councilmember Green?
Yay.
Councilmember Morel?
Yay.
Councilmember Moreno?
Yes.
Councilmember King?
Yes.
Councilmember Harris.
Yay.
Councilmember Jeruso.
Yay.
We have 7 yeas. Number 4, as to charge 2, in motion M23-424, namely that Gregory Joseph, in the face of a clear legal duty to tell the truth and to cooperate with a lawful investigation of the city council, did intentionally provide false testimony under oath before the Governmental Affairs Committee on August 31st, 2023, regarding the role of the recall campaign in connection with the City of New Orleans 2022 mailer campaign. Does the council find Gregory Joseph guilty of incompetence sufficient to support his suspension or removal from the city service? A
Yay.
yea vote is guilty, a nay vote is not guilty. Councilmember Thomas?
Yay.
Councilmember Green?
Yay.
Councilmember Morel?
Yay.
Councilmember Moreno?
Yes.
Councilmember King?
Yes.
Councilmember Harris?
Yay.
Councilmember Jeruso?
Yay.
We have 7 yeas. Number 5, as to charge 2, does the council find Gregory Joseph guilty of neglect of duty sufficient to support his suspension or removal from the city service? A yea vote is guilty, a nay vote is not guilty. Councilmember Thomas?
Yay.
Councilmember Green?
Yay.
Councilmember Morel?
Yay.
Councilmember Moreno?
Yes.
Councilmember King?
Yes.
Councilmember Harris?
Yes.
Councilmember Jeruso?
Yay.
We have 7 yeas. Number 6, as to,
yeas and 1 nay.
1 day.
oh, I'm
This is the
sorry.
neglected duty charge, right?
Yes,
Nay.
I'm sorry.
It's all right.
I didn't hear.
That's why they're individual.
6-1. Number 6, as to charge 2, does the council find Gregory Joseph guilty of gross misconduct in reference to his duties sufficient to support his suspension or removal from the city service? A yea vote is guilty, a nay vote is not guilty. Councilmember Thomas?
Yay.
Councilmember Green?
Yay.
Councilmember Morel?
Yay.
Councilmember Moreno?
Yes.
Councilmember King?
I do have a question.
Okay.
What is it, who determines suspension or removal? When is that determined?
At the conclusion of this hearing, if he is found guilty of any of one of the 6 charges, then he can be suspended or removed.
Right, but who decides which one is?
A motion will be made to do one or the other.
Okay, yay. Yes, yes.
Councilmember Harris?
Yes.
Councilmember Jeruso?
Yay.
We have 7 yeas.
Can you give us the tally of how many charges he was found guilty of?
All of them.
Oh, okay. That being said, since that has been concluded, I will now make the motion to suspend Mr. Joseph from employment in the city of New Orleans for a period of 3 years. Can I get a second? Can I get a second?
Yeah.
Okay,
Oh,
Second it.
no second?
no second. Just for the record, should we do a termination and a resignation is accepted before termination, the termination would not stick. So by suspending Mr. Joseph for a period of 3 years, that would mean he is not eligible for employment in any position in the city of New Orleans for a period of 3 years. Once again, I move to suspend Mr. Joseph from the employment in the city of New Orleans for a 3-year period. Is seconded by Councilmember Moreno.
Let me ask you this question. Councilmember Morrell, is it 3 year suspension or termination of the option?
We can choose to terminate or suspend him.
Okay. Is it? I don't want to interrupt, yeah.
Typically, and we can speak to our lawyer, typically, the law does not accept indefinitely.
Mr. President.
Adam, is my understanding typically under the law is that we cannot make perpetual periods.
Candidly, I've not looked at the law on an indefinite suspension. I mean, that's the practical effect of a termination. The benefit of a lengthy suspension is that you avoid litigating the issue of whether the Mr. Joseph could be immediately reemployed. Typically, the law, however, disfavors permanent indefinite remedies. So I would recommend a term of some sort.
Thank you.
Yeah, I just so I can fully understand this. So if we were to terminate, for example, there could be an argument that this individual could then be immediately rehired. But if we do a suspension with a certain year limit, then that removes the possibility of this person getting immediately rehired. Is that correct?
That's correct. And
Thank you.
the better reading of the charter is that if he is removed, that it's permanent. Because if he could be removed and then hired the next day, then this whole procedure and the council's oversight is meaningless. But to get to that answer, we would conceivably have to engage in some litigation, whereas a suspension for a lengthy term is very clear. Should probably be clear that the suspension is without pay.
I apologize.
But yes, Councilmember Moreno, you're exactly correct.
I apologize. Thank you for that correction. I will withdraw my previous motion and I would move that Mr. Joseph be suspended for a period of 3 years without pay from the employment of the city of New Orleans.
I have a comment, if I may. Can we do it until for the remainder of this current administration's term?
3 years candidly covers that without having to go into the months and days and hours.
I know. I would feel better if it would be since this administration hired him, the next may want to. So I just do it for the remainder of this administration's term.
Candidly, from my position,
I'll second that substitute motion.
well, it wasn't made a substitute motion, but if someone would like to make a substitute motion, I would entertain it. But to be candid, this is not meant to be a punishment to Mayor Cantrell. It is meant to be a punishment to Mr. Joseph. I don't think that we should, Mr. Joseph is the one who violated the law. Mr. Joseph is the one who has not participated in the process. And personally, I don't really care if the next administration wants to hire him on day one. I think a 3-year suspension is appropriate. If you'd like to make a substitute motion challenging that, that is certainly within your wherewithal. But I think a 3-year period is a reasonable period.
Okay. All right, well, I would like to make a substitute motion to suspend Mr. Joseph without pay for the remainder of this administration's term. Second. Do we do the vote, Madam Clerk?
I'm trying to get the most. Adam, is somebody gonna give us these motions?
I think someone, Adam,
We'll write them down. Why don't we treat that as a motion to amend his motion, to amend the term from 3 years to the continuation of the Cantrell administration and then vote on the amendment?
That makes it easy.
we're gonna give the staff the ability to draft the amendment after the vote.
Once we have an instrument voted upon, we will reduce it to writing.
Okay, thank you.
I'll accept the amendment. That way we don't have to vote, and we'll just vote on the amended. Mr. King has offered an amendment. I'll accept the amendment of the term, and then we can vote on it. So the amended motion shall be that Mr. Joseph shall be suspended without pay for the remainder of the current mayor's term. Is that correct, Adam?
Correct?
All right.
All right, so it was moved by Councilmember King and seconded by Councilmember Thomas.
That was the amendment, which I accepted. So
So, but we gotta vote as a body on that amendment, to the amendment.
Okay, let's just vote on the amendment. All right. I think if I accept the amendment, I don't know if we have to vote on it. Aye. All right, there you go. So on the motion as amended, I will move on the motion as amended. Can I get a second? Second by Councilmember Jeruso. Please vote your machines. Now we can use the machines again. 6 yeas, 7 yeas, 7 yeas, no nays. The motion carries.
Motion adjourned.
Second by myself. Any opposition? Hearing none, we're adjourned.